And I am going to share this to the proper title page so everybody can reference it later. This is one of those topics that not everybody wants to really think about at any moment. So it's probably better to just say, hey, check this video out later when you're in the right mind space. Okay, here we are. We are live on Facebook. Hello, everybody. Good morning. Welcome to Virtual Real Estate Chats hosted by Sabrina Beer. I'm the Director of Digital Media and Education, and this is all powered by Proper Title. Today, we have one of our return guests and one of our favorite real estate attorneys, Meghan Stokes. So Meghan, please say hi and introduce yourself.
Hi, everyone. It's great to be back. I'm Meghan Stokes. I am a real estate and also an estate planning attorney. So thank you, Sabrina, for having me back. I think the third time now.
Oh, is it? Yes, I
think so. Yeah.
It's the third time. Yeah. Well, I just obviously love tapping into your brain. So much information, and I love the way you explain things. And so for everybody watching, the way that this came about is I was talking to Meghan about estate planning and talking about the fact that pretty much I had really no idea what encompasses the words estate planning, but yet it gets thrown around all the time, especially being in title. I hear attorneys talk about estate plans, right? Well, here I am. I won't give my age, but my parents are in their late 70s. And, it's definitely something I want to make sure. I mean, we should all make sure, right, Meghan? But I want to make sure it's all set and done for my parents, God forbid, when that time comes. So I don't want to put anything manifesty out into the world. So I'm not going to use them as an example, as they are happy in Northwest Indiana. But if somebody, let's just say their parents are getting older and, people are having, unfortunately passing away or dementia or something where they're not of right mind. So if somebody all of a sudden, either their parents don't have in the state of right mind, or if someone passes away, what are some what's happening next? Like what happens with their home, with their investment accounts, with anything else, even the money in the bank?
Yeah. So I'm going to assume for this situation that they have no planning in place. It's not uncommon for people not to have planning in place. Somewhere around 69% of people actually don't.
Wow.
And just for a little foundational knowledge for everyone out there, an estate plan, it's thrown around a lot, like you said, Sabrina. An estate plan is really comprehensive plan to deal with what happens to you if you become incapacitated, and then what also happens to your assets, your estate, the things you own when you die. There's only what's that saying? There's only two certainties in this world: death and taxes. So as much as we don't like to talk about this, it's inevitable for everybody. So if someone passes away without any planning in place, we have to open up a probate estate in the court. It's a public process. Around here, it is about 18 months that's on the low side. If there's no will or no contests, if they have a will, they have to go through probate too. About 18 months because of the notice that we have to give creditors. Creditors have to have a chance to come forward and say, well, this person owes me $30,000 on a credit card. I need to be paid before anything goes to that person's heirs.
So let me back up for a minute. You said the first thing happens is it goes to probate court. And so what's probate court?
Probate is the legal process that your estate has to go through if you die with assets held in your personal name. So for instance, if I have a bank account, it's in my individual name, that's what's called a probatable asset. If I have a home and it's only in my name, that is a probatable asset. So that's the legal process for title to pass from the person who has died to their heirs, to their beneficiaries. Okay. And so, yep.
No, I was just going to say, okay, so the person passes away, and then even if, like, let's say their main asset was their home and they held it in tenancy in common, is that the right one where it gets passed down? Joint tenancy.
Yeah, joint tenants with right of survivorship,
Yeah.
or tenants by the entirety if it's a married couple.
Okay, so let's say it's a married couple, tenants by the entirety. I'm married to my husband. I die. My home goes to him. Do
Yep.
I still have to go to, does he still have to go to probate court because of my death?
Great question. So that, because you own it in joint title with somebody else, that would not be considered a probatable asset.
Huh.
So when somebody passes, we have to look at how assets are owned. And then also if any of those assets have valid beneficiary designations. So that's what I look at first. I look at all of the assets, see how they're held. Any jointly owned assets, for the most part, are going to pass to the survivor without having to go through probate. Any life insurance is a big one that has beneficiary designations that most likely will pass to the beneficiary outside of probate. And I say most likely because there's a few things that have to be true. The beneficiary has to be alive. It can't pass to, if somebody, if let's say somebody named their spouse as beneficiary, but their spouse died before them, they hadn't updated the beneficiary designations. Well, that's not a valid beneficiary. You can't, the money, it would fail at that point. And also a lot of people, if they have minor children, will put those minor children as beneficiaries, but they cannot legally inherit until they become an adult. So that would wind us up in probate court because a guardianship would have to be established. Somebody would have to be chosen by a judge to monitor those funds to make sure that those funds are being spent in a responsible way until that minor turns 18. So that's why I say usually it can avoid probate, but instances like that, well-intentioned people who think, well, I'm just going to leave this to my kids. This is my plan to leave my life insurance policy to my kids. Well, if they're minors, that's not, going to have the intended effect. So we look at all those assets, the jointly held ones, the ones with beneficiary designations. And as long as those individuals are alive and legally allowed to inherit, then those assets pass outside the probate estate. So then we're left with anything else that is owned, bank accounts in the sole person's name that don't have beneficiary designations, possibly retirement accounts, possibly, household belongings, cars, things of that nature.
Jewelry,
family heirlooms, art.
Yeah. So if I am in this scenario, I'm married, which I'm not, but if I was married and my husband passes away and we do the whole probate court thing. If I have a will, if he has a will and he has everything outlined in there where things go, do we still have to go to probate? Like, is probate court avoidable at all?
Probate court is avoidable. And the way to avoid that is if all of your assets are jointly held and have beneficiary designations, which is not always possible. Another way to avoid it is to have a trust. There's lots of different trusts out there. There's two main types, revocable and irrevocable. The revocable living trust is the one that I see mostly used as, among other benefits, a way to avoid probate.
Tell me more about the revocable trust.
Yeah, so the great thing with a living trust or a revocable trust is you can use the assets like you do if you own them in your personal name. So I have a house in my trust. I can sell it if I wanted to without any issues. I could add more assets into my trust. I can take assets out. So really you use them as though you would if you own them in your personal name. Now, the important thing with a trust is to make sure that you've properly funded it. And that means you have to retitle all of your assets that have title to it into the name of the trust. So for instance, if I have a trust, my assets would be retitled into Meghan Stokes as trustee as the Meghan Stokes Living Trust, for instance. And so that way, if you have everything titled into the name of the trust, you don't own anything personally, the trust does, and you can avoid probate court that way.
What is everything? Like if everything is retitled instead of, Sabrina Beer, it's Sabrina Beer, blah, 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 living trusts, blah, 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 that you said, what's everything?
It's literally everything. So assets that have title to it or a record of ownership to it, like bank accounts, houses, you just go down to the bank and you give them you can give them your full trust, but I give clients what's called a certification of trust. It's a couple-page document. The bank doesn't need to see all the terms of the trust. They only need certain terms. So you bring that document to the bank and you say, I need to retitle my bank account into my name as trustee of whatever your trust name is. The home, you do a quitclaim deed from yourself individually into your name as trustee of whatever your trust name is. You do that for all of your assets. The life insurance, you name your trust as the beneficiary. Your retirement accounts, if you're married, you put your spouse as the primary, because there's a lot of tax advantages that we don't want to get into right now. I don't want to bore everybody to death. There's tax advantages to spouse inherited retirement accounts. So we don't want to mess with that. So you name your spouse as your primary beneficiary and then your trust as your contingent beneficiary. So you do that with all of your assets. Business interests, you just transfer, if you own a business, you transfer your interest as an individual into the trust. So your name as trustee of whatever your trust name is. Even your personal belongings. Now, there's no real way to track title to a couch or your art. So there's just an assignment of personal property, for instance, that I include with my plans. It assigns all of the personal property, household belongings, art, furniture, family heirlooms, jewelry into the trust. So literally everything is owned by the trust. Since it's a living trust, you can sell assets, take them out of the trust, bring them back into the trust. It's very easy to do. So there's really no restrictions on how you would use your assets.
Okay, so I am not married anymore, okay, or never was, let's just say. I'm just me. And I have a living trust for some stuff. Maybe I have some things just I kept the way they are because I have a beneficiary on those already assigned. Do I have to put those things into the living trust as well?
I would.
Everything?
Yeah, I mean, I would be for this reason. If you decide to change your beneficiaries for whatever reason, let's say you had a falling out, you got divorced, one of your children squanders money, and so you don't want to just give them that money. Instead of having to change all of your beneficiaries, anytime you make a decision, all you have to do is just make a change to the trust. It's a lot quicker. It's a lot easier. You don't have to worry about remembering to change the beneficiary designations for everything. The beneficiary designations go to the trust, and then the terms of the trust say who gets what. A lot of people just split it equally between their kids. Some people have specific assets they want to go to specific kids. And so it's really just easier to only have to update one thing. They want to go to specific kids.
Sorry, I was looking at the comments and you started.
No, you're fine.
Okay, that makes sense. What if I was not proactive, because this is a very proactive thing, right?
Yes,
so if I was not proactive by calling you, setting up an appointment, saying, Meghan, can we sit down and talk about my estate planning, right? That's what I would call and say to you. Can we figure out an estate plan for me?
Yep.
For me, for my family, for whomever, right? And then we would make an appointment and you would go through all these things that you'd said, plus I know a lot more stuff because we've had a couple other conversations about this. But if I didn't do that, right? If I didn't do that and, you know, I pass away, or in this scenario, we'll just say I pass away and I have some beneficiaries for this and that, but my house is owned by just me. And I have, you know, 2 or 3 kids. What happens to my home and anything else that doesn't have a beneficiary on it?
Yeah, so that would go through the probate process. Once it goes through the probate process, so once any creditors are paid, once you know, attorney's fees are paid, because that's a court process, your estate, your family would hire an attorney to go through that process. The house would, if you have kids and no spouse, the house would go to all 3 kids in equal shares.
Okay. What if the will said that I just wanted my house to go to 1 kid?
And there's no other joint owner on it?
There's no other joint owner.
Okay, then that would follow the terms of the trust, or sorry, the will.
Okay. So probate court, you go into probate court for any assets that are not in the, either with the beneficiary or in the trust, right? So I can avoid probate by having this living trust, right?
Yep.
Okay. So if I don't have the living trust, or there's assets that never got put into the living trust, right? Or I have assets that aren't in the living trust and don't have a beneficiary, I have to go to well, I will not be going because I will not be alive, but my residing, what do they call it? The residing family members that are alive go to probate court.
Yep. Somebody would petition the court to be the personal representative of your estate, and there's a specific order that the like a order of preference, I guess would be the best way to say it, who would be like who could petition to be the executor. Would probably be one of your kids. That's the most common. Hopefully they can all agree on who will come forward as executor. Otherwise, there might be a couple of different petitions out there, and then the judge would choose. So if you had a kid who wasn't necessarily responsible, they could potentially become the executor of your estate, and they're supposed to make sure that the assets go according to the terms of your will. And hopefully they would, but we don't know.
So that executor of the state goes through some kind of legal pecking order, for lack of a word, or decided by the judge.
Yeah.
Okay. And so then that probate process takes currently about 18 months, you said?
Yeah, I have one client right now, very simple, straightforward probate matter. There's no conflict or anything. Luckily, she lives here. Her brother lives in, I think, California. And it's been pretty easy. Not a lot of assets, not a lot of steps to take. And the quickest we can close that out is about 18 months.
Crazy. So get a living trust, people.
Yeah.
Or get an estate plan. I mean, at the end of the day, right?
Something. I mean, some people frankly don't care what happens when they pass. And so they're like, it's really, I don't care if my family has to go through probate. I just want to make sure that these specific items go to these specific people, and they don't care. Other people do care, like how money is left, how easy it is on the family. They want to avoid probate. They want to make sure that their money that they're leaving their kids is protected from their kids' potential, lawsuits, creditors, or divorce, which is another benefit of a trust. You can protect your beneficiary's inheritance. So really, it just depends on the person and what's important to them.
And then why we should set up an appointment with you and know what's important to us, and excuse me, and like the family dynamic, right? Like, what if you love your son, but you don't necessarily love your son's wife? Like, just saying that there's so many different scenarios, right? Or you have that child that if you gave them some big asset, they're not financially responsible and they would just blow it. So you could do something else with it, right? Isn't there
Yeah.
something you could like, instead of somebody just getting the asset all at once, like let's say you've got 500 grand sitting in a bank account or something, that the person doesn't just get the 500 grand, that they get it in payments?
Yeah. So that you would need some form of a trust for that. You could, so I call that ages and stages, on when the money would be released to the beneficiary, to your kids. A lot of people split it into three. So for instance, like the age of graduating college, say 21, 30. And then I had a client recently go as high as 40 because they really wanted to make sure they had a parent who inherited kind of that way. And their parent told them, how thankful they were that it was kind of spread out like that, because they probably would have made not so responsible decisions on how to spend the money. And so spreading it out that way can make sure the money lasts for a long time. It's really, like I said, it's really just the preference of the client and how they want to move that money. Some people want to keep it in trust for their kid's entire life. And that is a really good way to protect that money from, the son's wife that the client doesn't like, or from the kid who has developed a gambling problem, or unfortunately, or drug and alcohol dependency. There's ways you can structure the trust to make sure that your kid still gets the benefit of the money, but they're not going to, spend it on drugs, alcohol, gambling binge in Vegas. So
Oh,
that's
I didn't know that. That's good to
yeah.
know.
Yeah, because whenever you go through, so if you have a will, the money you're passing the money, usually you're passing the money outright to people. So essentially it just goes right into their bank account. There's something called a testamentary trust, where any assets that have gone through the probate process, they're placed into trust after it's gone through probate. So those types of trusts, you can also do the same thing, but for those, you still have to go through the probate process, which a lot of
Interesting.
people don't like to
Well, yeah, and I would
do.
imagine that, I mean, thank you. I have not had to go through any kind of probate process, but I would imagine that 18 months, there's some stress associated with that, right? Constantly thinking about it, going to court, not being able to have closure for something because the thing is hanging out, and like just the mental capacity to wait that long for something to be finalized has to be really stressful too. So
Yeah.
yeah, so it seems like if I have the words right, that a trust, a revocable trust, a living trust, all of the same things, and for this
Yeah.
conversation, is a probate avoidance tool.
Yes.
And second to that is really like making sure, for me personally, this is like one of the things I'm going to write down after this call, is going through all my assets and making sure I have beneficiaries on everything. Right. I mean, it's not going to cover all of my belongings and all of my things. Right. But that helps. But what age do you like, when do I call you now in my 40s and say, Megan, like, or, I mean, am I old or young, or when do you call the attorney to create an estate plan? Once you have assets, or?
I would say it's never too late. Um, a lot of times life changes are what bring people in to my office. New kids, maybe they just went through an issue with a parent or in the family, and they're like, oh, I want to avoid this. Tell me what I need to do. But I think it's also important to point out, we've been talking a lot about what happens when you die, but a comprehensive estate plan also deals with what happens if you're incapacitated. So meaning you are still living, but unable to make your own decisions, whether it's, financial decisions or medical decisions. A lot of times young people don't do any planning because they, they don't have kids. They don't think they have a lot of stuff. They just don't think about it. We tend to think we're invincible when we're younger. But what happens if you get into a car accident and someone has to decide medical care for you? You're asking that person to try to figure out what you would want. That places a lot of stress on people. So I'm doing a kind of a promotion now where college-bound students can get a free medical power of attorney, because once they turn 18, their parents no longer have any right to their medical records or to be a part of their care. And I mean, 18, yeah, you're an adult, but I mean, a lot of parents still do a lot of things for their kids when they're in college. Crazier things happen, a bad drinking weekend. I mean, we hear this in the news all the time, people thinking they can take 30 shots in a row, and then now all of a sudden they're in the hospital. Yeah. So it really deals with, comprehensive plan really deals more with, what also happens when we're still here, but unable to communicate our decisions.
Yeah, and that could be, right, that could be physically disabled, dealing with medical, or just the onset of dementia and Alzheimer's, all of those, or I would assume even some forms of mental health diseases and stuff too, right? Where you're just not able to make decisions.
Yeah.
Yeah. And that the college thing, I'm so glad you brought that up, and we'll kind of close out with that, I think, because I think it's really important. Is when I graduated from high school, the Friday before classes started on Monday, I got hit by a drunk driver. Crazy.
Oh, wow.
And I was 18. And my parents had to make a lot. I was in a coma. My parents had to make a lot of medical decisions for me. Like, I couldn't make them yet. I was an adult. And if they didn't have that, they wouldn't have been able to make those medical decisions the same way, right? Or if I didn't want them to make the medical decision, right? And
exactly, yeah.
I wanted a different family member that I'm closer to, or that brought me up, or whatever, to make that decision. That would be something to do too. So these conversations are big and heavy, and they're a lot, but they are so important, because all we can do is live day to day. We have no idea what's going to happen tomorrow or an hour from now. And so to get your estate in order is so important to do.
Yeah.
And to call someone like you as soon as we start thinking about these things. If you do have children that, are getting up to that 18-year-old or going to college, like, call Meghan, sit down, talk about, if you've never had your estate plan discussed, especially if you own a home, have money in the bank, have a 401k, have a Roth IRA, whatever the things are, call Meghan. I promise you, she's very easy to talk to. I will explain everything. And so, yeah, I mean, any closing remarks?
I mean, just kind of really kind of drive home the point here. We don't need an estate plan until we need it. And if we don't already have something in place, it's too late. You can't go back and try to put one in place, especially just real quick, probably 30-second story. My parents have a friend who is a little bit younger. My parents are in their mid-60s. He got an Alzheimer's diagnosis, and he had no planning in place. And so he can't go, he has an Alzheimer's diagnosis at that point. He's not in the right frame of mind to develop an estate plan. So when he needed it, it was too late. So yeah, it sucks. Nobody wants to talk about it. Don't want to talk about it, especially if we have kids when we're gone. It's very emotional. But it's something that, we need to do.
Yeah. Well, thank you for having this conversation with me and everyone watching.
Yeah. Thank you.
any questions, wants to call Megan, her contact information is going to be in the comments below. Feel free to reach out. Tell her you saw her on your Facebook Live. And yeah, and Megan, thank you for just being such an amazing resource for me and for others. I really always appreciate the time that you take to answer questions. So thank you.
Thank you. I appreciate the platform.
Thank you. Have a great day, everybody. Get your
Bye.
estate done.
Bye, everyone.
Bye.